Please, Lordship. Lordship, I beg to mention item number 7. Lordship, I'm praying for 1 week's time in this matter, Lordship. We're supposed to give the arguing counsel is supposed to give a reply against the argument. I'm praying for 1 week time.
Lordship, they've informed us yesterday, Lordship. No, 1 week, no?
On consent by the parties, this is matter of 1 week.
Highly obliged.
Obliged, Lordship.
Supplementary list, item number 1.
Lordship. Wait, please, Lordship. Lordship, this matter is heard, Lordship. Was already heard, Lordship, and is fixed for filing of written argument. So the written argument is ready, Lordship. I may file it today itself.
What about the other side?
Lordship, Sir did not was appearing, Lordship.
Yes, where is he?
He's probably engaged in the other court. He's not here, Lordship.
You're filing.
Lordship, it's ready, Lordship. I'll just give it to the court masters.
Let Mr. Demnar come. And you keep yours.
Yes.
Let him come, and if he files, then I'll pass the orders.
Okay. Obliged.
Daily list, item number 1.
Em đã không có chú, no one would have not. Don't want to have got nay. Don't want, sir.
Please, Lordship. My Lord, we will be filing our reply in course of the day.
He has filed.
Yes, my Lord. Rejoined to the affidavit. We'll be filing in course of the day, my Lord.
How long? Issue of maintainability. What is
my Lord? Yes. On the issue of maintainability, my Lord, he has filed the affidavit, to which we will be filing rejoinder, my Lord.
What rejoinder is required?
My Lord, that I cannot say. On the last occasion we have prayed, it was
rejoinder
allowed,
would be
so
only on the issue
yes,
of facts. When you are contributing any facts, then rejoinder would be applicable. This, you see, maintainability is purely a question of law.
My Lord, we have already our affidavit is so.
That would have been sufficient.
We will be filing in course of the day, my Lord. Kindly have the affidavit on board, my Lord. We'll be filing in course of the day. We can have it next week.
This is on Monday then.
My Lord, make it Tuesday, my Lord. Tuesday.
You said you'll file in the course of the day.
My Lord, Tuesday, because I will be having some difficulty on Monday, my Lord. That is why. Tuesday, my Lord, just a matter of 1 day, my Lord. I'm requesting. For affidavit, we are planning to. We are filing in course of the day. We'll serve an advance copy to my friend, my Lord.
On the last date, they had prayed maybe to be fixed on 22nd or 26th, like that. They had prayed for. Learned AG had prayed for, and today they are filing.
Because my Lord, AG won't be here, my Lord. That is another difficulty.
So when are you free, Mr.?
No, it's up to your Lordship.
It's up to you now.
No, first of all,
is in your court now.
I simply pray that it should be copies should be furnished immediately to me.
I have not filed it, so my Lord, how can I give in the advance? Once I'm ready with the affidavit, it's signed by the officer.
The last time also I had waited till the evening, my Lord, to receive simply the copy. I hope in the first half itself.
My Lord, let's not speak about that. What my friend has done during the course of filing the registry officials know, my Lord. Even before the filing was not accepted, what he was eye-dropping in the, my Lord, there, we know everything. So let's not go to that effect. I'm praying is that
back to Guwahati instead of waiting till whole day. So I simply pray that copy of it may be submitted.
Nowadays it's very simple. If you want a copy, they can give you a soft
email
copy.
Also, my Lord. We can WhatsApp. Email can be done.
It can be sent to you by mail.
Not used to, sir.
That is okay. It's just
that's why
there's no issue of responding to the rejoinder.
Because previously they said that before this particular day they would be filing. Before this particular day, they will be filing, but till now they have not filed.
What Ms. Kolni said is also true. You see, once it is filed in the registry, you have to give time to the registry to process.
Yes, my Lord.
By the time it's available,
and they are very particular about every affidavit, my Lord.
That of course.
So it takes time.
We cannot stop. Okay, if you wish, we can have it on 22nd then. By the time you you would have received a copy.
My lord.
So today I'll receive a copy. I hope so. So don't do it.
Who are they? Huh? Who are? They are phone. Come to our home.
Or day
20th then.
20.
Yes. Miss
My lord.
20.
20. Miss R.
Admission hearing. For admission.
Yes. Miss Arpani Ladat. G. I submitted that the reply to the counter affidavit filed by the respondent will be filed in course of the day. Accordingly, it is stated that matter may be taken up on the next date. Mr. Ibora appears for the respondent. As agreed to by the parties, this is matter on 20th. 20.
I simply pray it may be furnished on the first half itself. That's my prayer.
My lord, once the officer will sign it, then only I can give the corrected copy. If I give him now, later on some changes come, it will not be correct on my part also to give him.
That is, sorry, that is between you.
My lord,
How you do it.
I'm obliged, Coach.
Item number 2.
Please, your lordship. Lordship, we had sent the rejoinder for signatures, but we came to learn that the petitioner is abroad, my lord. He is returning on the 27th. Kindly have this matter after 27th, my lord.
So let it come up for hearing in the meantime, they can
Yes,
file it.
it can come up for hearing.
What is, you are supposed to file what?
Rejoinder, my lord.
Why would it come for hearing?
Because against the union affidavit, they want to give the rejoinder. For Cantonment, I have given
still,
all.
you see, pleadings would not be completed then. How can we go first with the hearing, then?
No. It is 27 duly coming. Let it come up for hearing. In the meantime, he can file it before that.
So we'll list it on 2nd then.
Well,
Monday.
On second.
Monday,
As you-
Mr. Ahmed, lawyer counsel for the petitioner, has submitted that the rejoinder affidavit could not be filed today as the petitioner is out of the country and would return only later next week. Would return within, Mr. S.P. Mehta, senior counsel, has submitted that the petitioner may be allowed to file the said rejoinder. However, this matter may be posted for hearing in the meantime. Accordingly, as agreed to by the parties, this matter for hearing on 2nd. The petitioner is directed to file the rejoinder in the meantime with copies to be furnished to all the respondents.
yes.
That's all right.
Item number 3.
Lordship, in this case, we have received the affidavit in opposition by the respondents number 7 to 10 just yesterday. Mr. Sen is on his legs, my lord, for a motion matter. Kindly have it at the end of the board. He has to make some submissions, my lord.
After some time, my lord. Because even senior counsel also make some submissions in this matter. So the matter we can take after some time, my lord. At the end of the board.
End of the board then.
End of the board.
That's good.
Item number 4.
Yes.
Same status, Your Lordship. The regional director has not done anything, especially in Amrit Simmons.
There any detention fees?
You are certain that the
Yes, it's already filed. Everything is pending before.
the matter is before the
Your Lordship.
director, ROC.
Your Lordship.
Not ROC,
The
regional director.
regional director.
The regional director is
So
like,
regional director fix the date.
he is the authority to decide on the matter.
Yes, regional director is the authority to decide.
He is invested with the same power as an ROC.
Also,
He is not as a ROC, but he is the regional director. He is above than the ROC.
above.
Above.
So the Companies Act,
ROC will be
the
submitted.
Companies Act provide that he can entertain such
He
petition.
can deal with it.
Yes, he is competent authority.
He is invested with the power.
But if he's season of the matter, then why is it taking so long?
Your Lordship, the problem here is because
If the
too much
petition
of reshuffling. Every year the ROC or regional directors reshuffle. So a new one joins in and again it takes time.
Regional director will fix the date and after
Have you
that.
furnished copy of this order to him?
I have communicated the same to my clients.
See, because this court cannot direct.
I totally understand, Your Lordship.
Cannot direct the another authority, competent authority or quasi-judicial
Your
body
Lordship.
to, to do something or not to do something. It's
Your Lordship, I have a suggestion if Your Lordship can pass some observation again so that
They will see if this date has been fixed and then after
in the
that they
previous-
appear, it will be on the
in the
very
previous
date.
order, I've only make
Your Lordship, I've communicated the same on the last date.
on pre-made by the parties. This is matter after 4 weeks.
4 and 5, Lordship.
4, 5, and 6,
five.
na?
Oblige.
4, 5, 6.
4, 5, 6.
4, 5, 6.
4, 5, 6.
Item number 8.
May it please your lordship. My lord, I would like to pray for at least 2 weeks' time, my lord, because I'm not well, my lord, to conduct the hearing today.
No objection, my lord. It's not well.
You sounded not well, or really not well, or
No, my lord, actually I was not well from
fit for
yesterday.
some other profession. That's a joke.
2 weeks, man.
Mr. Learned Counsel for the petitioner has sought for accommodation on the ground that she is not feeling well today. Mr. P.O.B. Learned Counsel for the respondent has no objection to the prayer made. Accordingly, as agreed to by the parties, lays this matter after 2 weeks.
I do apply, my lord.
Second call for supplementary list. Item number 1.
Your Lordship, this matters, when this only one this petitioner is remained, and I had thought to discuss with the army officials. So how to solve this?
No, the question of solving doesn't come. Matter would proceed ex parte against the school authorities.
The matter was heard already.
Matter was heard.
So,
You are representing union.
Yes.
If you chooses to contest or file a written argument, it will be taken on board. If not,
So,
then order will be passed.
so Your Lordship, that's because only this one petitioner is remaining in this matter.
So you choose not to contest.
So this, I was thinking that's better to inform to the school.
There's no issue of thinking, Mr.
Your
Either
Lordship, I just
Either you state the law or not. Yes, fine. It's a written argument.
let it come after 2 weeks, Your Lordship.
Why? I mean, see, it's 2019 matters.
Let it come after 2 weeks, Your Lordship. please.
Judgment is reserved.
Lordship, from my side, the written argument is ready, Lordship. Just that
Mr.
it seems.
Learned Counsel for the petitioner has filed the written argument.
Lordship, I'm seeking for next week, Lordship, because there's a slight change in the party's thought. There's a slight defect in the party's name here, Lordship.
You correct that and file it in course of the day.
Lordship, that can be done, Lordship, in course of the day.
Mr. Learned Counsel for the petitioner has submitted that he may be allowed to file the written argument in course of the day. Mr. R. Devnath, Learned CGC, has reiterated that he is representing only the Union of India and not the other respondents. Has matter proceeded ex parte against the other respondents?
Lordship, they have filed a common affidavit, Lordship.
Whatever the case may be, file a common affidavit.
Yes, Lordship. The managing committee and the
Union.
Yes, he is appearing also.
You file a common.
See the affidavit, if I'm not mistaken. 4578.
Where is that?
4578 is appearing. This is your affidavit, no? One. 4578. I'll just see. Five seven eight has filed also, but this union has not filed also. Union has not filed, perhaps.
No, Union of India is respondent number
6.
Respondent number 6 also.
6.
And the affidavit which is on record is only with respect to respondent 4, 5, 7 and 8.
So, where is the order where the matter has proceeded ex parte against this respondent 4, 5, 7 and 8?
Lordship, perhaps that would be in the earlier order, Lordship,
Can you
because
point out?
that will have to ascertain. So,
where is you just check the order.
or else Lordship, matter can be taken up next week, Lordship, Monday.
We cannot just wait, linger on this point. We have all the time in the world, Mr. Har.
Principal, I cannot.
This is the managing committee. Common affidavit was
Yes,
filed.
order dated 25.
Yes, Lord. So my
25/7/2024. This proceeding has gone ex parte against respondent 4 and 5.
4 and 5. But a common affidavit was filed also by Sir Dimnan. Respondent 4, 5, 7 and 8.
You give you cite relevant authorities which says that once affidavit is filed, matter is not pursued in a hearing. How is the matter to be dealt with? Whether the court will take cognizance of the affidavit on record without hearing them, or whether it can ignore that altogether. That authority would be required.
Lordship, I will try to assess this for Lordship. But Lordship, then the matter may differ to 1 week, Lordship, for this this written argument, Lordship, because I'll include that in the written argument, Lordship.
Mr. Devnath, if you wish to file written argument, you do so. If not, if you don't want to press, then it's okay.
No, because problem has come up here. Union of India, this the 6 and 7 is the Assam Regional Center.
Union of India,
and Deputy Commander.
So Union of India means Secretary Defence or what?
Represents the Secretary Minister of Defence.
Yeah.
So here, if you consider even the Assam regiments are under the Union of India, and then Commandant Assembly Junior Center, there's Union of India. So when this school has filed this affidavit, and they mentioned 7, 8 also. So this is the problem has come to me. Otherwise, there is no problem in Union of India. So this is the matters. In some extent, this affidavit even I can rely. So what's happened here, due to this, I was trying to convince this Assembly Junior Center. If they are the member of the managing committee and others, then after this, if this one issue is there now, they can settle. So this is the thing of mind. If it is, then ultimately already 2 persons already retired and no action, pursuit action is taken, and she is continuing. So in such situation, I was thinking about it.
If she continue, allow her to continue. She has only a few years left.
So, that's why I was thinking this. If I can take some associated people,
Let
they are the
him
managing
take
members.
instructions in that case, Lordship. Let him take instructions.
Because I was thinking you will say if the order pass also, it will be no action system, pursuit action, and then another thing is there she is continuing, and there is rules I've seen. No action has been taken as such to remove. So in such situation, I think unnecessary.
You have to get a specific commitment.
Yes.
See, there must be a communication in writing that the school authorities have considered the matter of so and so,
Only one,
and
it should not be precedent.
has decided that she will be allowed to continue in service as a special case to her. That's all. Once you say that, that means this court will have will not go into the trouble of
So many matters, and moreover
preparing the
this.
judgment.
Yes, Lord.
Because after when this, they are not having any grievance.
In any case, the matter will go against you. There's a related judgment by this court. So the only thing is that it's for them to, if they can make a good case in their written argument, otherwise if they destroy their own case, then they finish. So it's up to you. You get your instruction.
Let him take instructions.
So I'll fix this matter after 2 weeks.
After 2 weeks, then also.
Gunung tu mana? However, the learned CGC has once again made a prayer that he may be allowed to contact the other respondents and seek necessary instructions, even if a relevant additional affidavit is required to be filed, the same would be done so. That is concerning the the same would be done so. That is concerning the service condition of the sole respondent herein, Srimati Mosami Paul Chaudhary. Hopefully we have to sentence from the last. Itu pomsai itu same will be done so pomno, and that is the same will be done so. Accordingly, on prayer made, this is matter to.
Lordship, just one prayer, Lordship. With regards to that written argument, Lordship, that part may be deferred, Lordship. We'll wait for their instructions and see, Lordship. Because if we file the written argument now, Lordship. Yes, Lordship.
No, you see, Mr. What you can do, you have your own course of action.
Yes, Lordship.
You file your written argument.
Yes.
If he gets some instruction, which I doubt he will.
Yes.
But at least that to that extent, some leeway is given to the respondent. If Mr. Debra can get instruction and file the affidavit, well and good. If not, matter is closed. The court will take into cognizance only your written argument on
Written
board.
argument also. I understood.
So you file that in the meantime.
Lordship,
Not necessarily
in the,
today.
Yes, in the meantime, Lordship. That
not
was,
necessarily
that
today.
was my prayer, Lordship.
I file it in the course of the day. Upon it in the course of the day, we'll file the written argument within the next day fix.
Lordship. Obliged, Lordship.
Second call from daily list, item number 3.
Yes, Mr. Sawan.
Mr. Sen was
No,
supposed
have
to
you
be-
filed your counter?
No, my lords, we are not filing.
You are not
In
filing?
fact, Your lordships kindly have the impugned order. That's at page 339.
Yes.
Your lordships can have page 340. Well, here the impugned order has been passed by only one executive member.
Passed by?
Only one executive member, my lord.
Yes.
Your lordships kindly have the act, that's at page 44 of the writ petition.
44?
44.
Yes.
Your lordships will have section 25 authorization.
Yes.
The executive committee may, by order in writing, authorize 2 or more of its members to exercise on its behalf any power or powers conferred upon it by this act, and anything heard, any act done or order passed as such by such members of the executive committee shall be deemed to have been heard, done or been passed by the executive committee. My lords, here in the instant matter, only one of the executive members has been passed. Your lordships, recently, my lord, in the coordinated bench of this honorable court, we have considered to the extent that this matter has to be sent back to the executive committee. Lords will be allowed to
Yeah, I
place the
remember
judgment.
that
Yes.
order. Just
Para 1, 2, and 3, my lord. So to this extent, my lord, the matter can be remanded back to the district council for reconsideration afresh.
yes. You are appearing for?
So 17 for
So this is the law.
Lordship, I'm grateful, my lords. They've been very fairly, they've conceded this position.
You would,
Because we believe law mandates that at least.
inevitably it would be. So,
First consideration.
Maybe send back for reconsideration in accordance with law.
what are the facts of the case, Mr. Sen?
My lord, I'll just have the brief synopsis. My lords, the Mintris and the Basans of the CM ship had filed a complaint against the CM.
You are the CM?
No, my lords, I am the complainant.
Oh, you're the complainant.
We are the Mintris and the Basans, my lord.
Which CM ship? William.
William CM ship, my lord.
Dated 26/10.
Yes, my lord. 22/10/24.
But in your synopsis you have written 26.
No, this is the date of the complaint, my lords. 26/10/23 is the complaint that we filed.
Yes.
And the impugned order is 22nd of October 2024.
Oh, okay. But Mr. Essen, learned counsel for the petitioner, who has submitted that the Mintris and Basan of Himam William as complainants have filed a joint complaint dated 26/10/2023 directed against the CM of Malaysia. This complaint was taken on board by the Executive Committee, Khasi Hills District Council, Autonomous District Council, and the same was disposed of by order dated 22/10/2024, purportedly by the Executive Committee. However, where is the impure order, Mr.?
Well, it's at page 339.
However, by the said impure order, what is noticed is that the same was passed only by the Deputy Chief Executive Member, who is the sole executive member who has signed the same. At this juncture, Mr. CCT Sawa, Direct Counsel for the respondent KHCDC, has led this court to the provision of, where is that provision, Mr.?
Page 44, my lords. Section 25.
Provision of the, what is the relevant?
Page 37 is the Khasi Hills Autonomous District Appointment and Succession of Same Deputies, Same Electors and Rangbashanang of Milliam Sameship Act 2007.
We can take a page
37.
37, no? Let this quote to the so and so, particularly section
25.
Section 25, which reads as follows. I am to go. Mr. Sawa has fairly conceded that the impugn order has been passed without the appropriate authority, and as such the matter may be, and such there is no objection if the matter is referred back to the Executive Committee for reconsideration of the same and for an appropriate order to be passed by the relevant authority. Parties have been heard.
By the previous dispensation, my lord. So we'll have to be reheard.
Yes, very good.
Kununtogo, the last line. You are appearing for
the same.
Same. You have no objection, Mr. Letter Counsel for the respondent CM of William has no objection to the. I Langatumo, Mr. Letter Counsel for the respondent CM of William and Mr. Letter Counsel appearing for the respondent 9 and 10 have no objection to the submission made. Mr. Sangma has also referred to an order passed by this court in
WPC 32.
In the case of Loving Stone Kharkongor, wherein this court by order dated 5/5/2025 in WPC 32 of 2025, considering a similar and almost identical issue, had passed an order directing the parties to be heard once again by the Executive Committee. It is relevant to know, it would be relevant to extract portion of the observation of this court in the said case at para 2, which reads as follows. I know not do no need.
Instead of the Act of 1959, my lord, the Act of 2007 will be.
Pardon?
Instead of the Act of 1959, the Millennium Act
Yes,
2007.
no, that's why I'll quote this this portion.
My lord.
In this view of the matter, from there. In this view of the matter, as the old act
My lord.
Till
Incompetent, no lordships can have to affliction.
incompetent. Accordingly, note submission you send. Mr. Sen Laret, counsel for petitioner, has also no objection to the proposition that the matter be referred back to the Executive Committee for fresh consideration. Accordingly, on pre-made this, only on consideration of the submission made, this petition is hereby disposed of with the direction that the petitioner approach the executive committee for the matter to be heard afresh. The respondent KHDC, particularly the executive committee, is also directed to take up the matter and to hear the parties and dispose of the said complaint following due procedure of law. All the other attending respondents who are party to the said complaint are also allowed to make their appearance before the said executive committee on being noticed.
If your lordship sees para 3 of that judgment, it says expressly that the impugned order will be set aside, my lord. Otherwise, they may be influenced with the findings in this particular order. I know it goes without saying, but then there has to be an express finding that this order is set aside, my lord, for want of jurisdiction. Please see para 3 of that order.
Okay. Shuai kato. Na ada tu competent day. Next para. As submitted by Mr. SN, the impugned judgment herein is hereby set aside for one of jurisdiction. Now the next spring no.
They have some time frame. Please. And would your lordship be kind enough to direct a time frame, my lords? Perhaps 6 months?
Time frame is never the.
And the cage reviews otherwise be willing, my lords.
Any.
Can you leave it to your lordship?
See, you know very well. If somebody tells you to do something, you do your best to not do it. The best thing is to implore. No, but see, whatever the case may be, if the proceeding takes a inordinately long time, you can always come back to this court.
We'll dispose it of expeditiously.
Otherwise, as I've said earlier, in the other case also, this court or any court for that matter would be want, to interfere with any proceedings of a quasi-judicial, authority. So that's it.
Hello, we just crave lordship's indulgence. Item number 1, my friend is here. We've served a copy of the rejoinder. Lordships will recall the last statement was listed. The learned AG had appeared. He had expressed his inability to appear next week. He's booked with some matters in the Honorable Supreme Court. Lordships will recall we had fixed the date for hearing on the 22nd.
No, we have fixed it on 20th.
That's what I recall, my lords. The learned AG had made a prayer for the matter to be listed on the 22nd.
Mr. Bora,
for hearing.
You were there, no?
He was here on the last date.
Matter was supposed to be fixed on 22nd. Today we had fixed it on 22nd.
Today is on 28th, I think. 28? Item number 1.
No, on 20th. 20.
20, my lord. So I believe the learned AG had made a request that 20th he would not be here.
Okay.
So I'll just come back with the date, my lords. I'll inform them.
Okay, no, Mr. Bora is here. If he agrees on the date.
Yes, I'll just come back. Just it'll be within that week itself, my lord.
No, just tell me which particular date.
I think he had said 22nd.
Sure. 2-2.
No, I'll just confirm that.
If he has no objection,
yes,
we'll fix the date 22nd.
Yes.
Otherwise, earlier.
With his agreement, my lord.
If 20 is confident, it's okay. If not, then okay.
So with his agreement, I'll just provide a date. I'll just speak to the learned AG and get a date.
Okay, fine. Then you talk to the.
Yes, I'll speak to them. Highly obliged.
But you get his consent.
Yes, absolutely.